discussion, I decided Chris Rock rocks. And this slide says it all in terms of contextualizing, looking at the program for the next 3 days, and thinking through how do we understand law, legality, accountability, rule of law, etc., and power, and how power intersects with law in the areas of race, gender, class, sexuality, orientation, resources, socioeconomic realities. And I thought this was great to kick off for our 4 panelists. Jamila Omar, who's at the University of Cape Town, Joel Madiri from the University of Witwatersrand, Nalundi Luwayo, who's from the University of Cape Town, the Land and Accountability Research, and Sanele Sibanda, also Wits, I think it is. So thank you very much to the 4 panelists. When the slide went out to them, the responses were, yes, this will be controversial, but it'll also provide a space for us to think about justice, to think about power, to think about law, to think about, and Penny's mentioned, the importance of connecting the global and the local. And you know, as I get older, I realize there isn't 6 degrees of separation. I came in yesterday and looking at one of the UK papers and the government challenge to the Brexit judgment in terms of should Parliament be playing a role in terms of how the UK gets out, when, and the process is to be followed, and the government, the executive, arguing that this is a decision of the executive challenging the judgment of the Supreme Court. And it reminded me of President Zuma and the Public Protector's report. So global to the local, and we can see the synergies and linkages. The relationship between law and power. Does law serve the society, especially those who are overlooked and underserved? Access to justice and to justice itself. And I think, you know, for many of us sitting in this room, depending on our context, our realities, where we've come from, the student protests in 2015 and 2016, I think raised, for some of us, a huge amount of trauma and unaddressed trauma in terms of, I mean, I was taken back to being a 5-year-old when a private security person prevented me from entering the law faculty building. My sense of rage was so overwhelming, and I couldn't place that rage because for people who know me, know that I'm a very calm person, and rage is not something that's part that I have ever exhibited. But standing there in front of a guy in military fatigues who was 3 times my size, and asking him why was he racially profiling black academics and black students and not allowing us into the building. He had a sense of power, and he was using what the university had an interdict. The university had contracted private security. Securitization, militarization of our campus during this time brought out the 5-year-old in me, but I wasn't the powerless 5-year-old who during apartheid had the apartheid police kicking down doors, assaulting my parents, children crying, and not knowing what to do about it. I was an adult with power, standing up to someone who was exercising power using the lens of the law and telling me that I couldn't get into the building and get into my office, and asking me for identity, which reminded me of apartheid, and carrying the past laws and carrying some form of identity. So the protests raise a whole lot of issues around law, around justice, around accountability, around fairness, but they also raise the issue of how do we move forward? What are the demands? And how does power get exercised when demands are made for free education, free education, for equal education, for decolonized education, but situating all this within the larger global context of what's going on in Europe, the rise of the right wing, the issue of immigration, it's just horrific. And it's not just human rights lawyers that are agonizing over the global and the local, and the challenges to jurisprudence, the challenges to constitutional values. Because it's making, as Penny said, it's making us reflect on pre-1994 when things were being negotiated. Did we negotiate too many things away? Are we open? Is this generation now, my generation, open to the questions that our students are asking about us selling out? How do we protect the constitutional value but also be open to having a discussion? And my hope is that each of our panelists and the audience will reflect on this and reflect on this moment of law and society in South Africa, 2015, 2016. It was coming before that, so it's not just about those 2 years. I think it's also a moment for those of us in South Africa to think about where we've been culpable in not addressing things that were within our ability to think about, to talk about, and to address. So, as Penny said, I think we are in both exciting and difficult times come 2017, but I also have hope that we can look and see each other, we can listen and hear each other, so that we can move forward, but not within a paradigm of business as usual, because that's not going to work for any one of us in 2017. So thank you very much to our 4 panelists. That's all you're going to hear from me. And in no particular order, Joe?
I was thinking about this quotation, apartheid was legal, slavery was legal, colonialism was legal, and I'm not exactly sure about that. I think that colonialism, apartheid, and slavery were only legal according to the culture and morality of Western civilization and of colonizers. As you will know, Africans who were interdicted by colonialism had their own conception of law, had their own moral codes, had their own rules and practices of social organization. As I understand African jurisprudence, the primacy of human life, the centrality of a sense of balance and harmony in the cosmological order would prohibit the kind of terror and cruelty and violence that characterizes these systems of violence. And so the erasure of the colonial from the way we think about South Africa, and the erasure of conquest in particular in the way we think about South Africa, is highly problematic. So quite right, I don't think those things were legal. They were profoundly immoral and unjust, but they were illegal according to the law of the people who are indigenous to the continent, and continue to be so. So I think, I'm not sure I necessarily agree. So I agree, of course, that legality is a matter of power, not justice, insofar as it allows questions of power and inequality to surface. But I don't think they were legal at all. I think we still live in a settler colonial white supremacist social order, and that these injustices remain illegal until they are resolved through a program of historical justice. I'll leave it there.
Thanks, Joe.
Thanks, Rashida, and thank you to the organisers for the opportunity. I also had some sort of initial thoughts on the quote that's put up behind us. My first was, it brought to mind this idea of form following function. So I was thinking to myself, what was sort of the purpose, what was the reason for systems of, colonialism, for apartheid, for the atrocities of the Holocaust. And it sort of, for me, raises this persistent question of why is it that law of all sort of disciplines, of all sort of structures, lends itself to making legal what is, as Joel has said, something that is patently illegal and patently immoral. And so I'm intrigued by the sort of the fibers and what it is that law actually clothes. What is it that law sort of protects? What is it that it enables? And fundamentally, I think that the last line of the quote brings that to the fore. That for me, law is absolutely about power, and it's about giving, in some contexts, this guise of legality to what is basically the practice of the powerful over the powerless. And so my second thought sort of built on that, and I was asking myself, if we're talking about law and society, can we say with confidence that our law truly does enable us to live in a society where atrocities like that can never happen again. And of course there are the absolutely meaningful and obvious ways in which our law has been corrected and changed to make sure that we don't ever backslide. But I am struggling to really believe that we've properly interrogated the underlying power dynamics that would truly protect us from slipping back to something that's reflected on the screen. And thinking about it in the context in which our centre works, which is around issues of land rights and customary law, you're seeing a very sort of clear, actually, power play by traditional elites and other elites who are well positioned, and their use of power is playing out regularly in people's lives. And what you find is that there is the use now of the law to give that power the cloak of legality, to give that power the cloak of acceptability. And so fundamentally, law ends up therefore enabling practices that are at their heart about an exercise of power by the powerful over the powerless.
Melinda, can I ask you, in terms of when you talk about power and the law, and how it gets used or doesn't get used. And I'm thinking back on the constitution-making process, the negotiations, the constitution-making process. And we had this wonderful kind of moment, in a sense, and I'm talking now from a different generation, of the use of media, of consulting people, of including people. And I suppose in a very utopian, idealistic kind of way, the use of radio, TV, comic books, going out and consulting people, asking, what do you understand? Or when I say the right to life, and it ranged from abortion to the death penalty issues. And in a sense, I feel society was included, but I also feel a sense of, so who was it that was included and who was excluded? Do you have some views on that?
So, I think that's an incredibly pertinent question, Rashida, and particularly for some of the work that we're doing in the rural parts of South Africa. I'm always struck by the sense of ownership that rural communities have of the Constitution, of the process of liberation, despite the fact that of all South Africans, their lives have perhaps changed the least. And I'm still not 100% sure how to describe that or what to make of it. But there is this very decided ownership of the fact that, the liberation struggle and the principles of the struggle were very much formed by those communities. It was fundamentally a prospect and an idea that they committed to. And so even though perhaps we haven't fully succeeded in realizing the transformation of their lives in ways that are tangible, and particularly, again, in the context of land rights, people are still very committed to the ideas and the ideals of the Constitution in those areas, but in a way that is very much based on an understanding that they formulate on their own terms. So it's an understanding that is wholly about owning the concepts as opposed to being told that the Constitution gives you a right to dignity, therefore this is what your dignity looks like. It's more steeped in this idea of, I have a sense of what my dignity is, I have a sense of what dignity is for me, and that is what I aspire to in my country. And I think that for me, the tension lies in the fact that our lawmakers, I don't think, have quite gotten right the ability to properly hear what people are saying. So if I think about what's happening at the moment, which is public hearings on this traditional conquest and leadership bill, which is a piece of legislation aimed at recognizing traditional leaders, but also at including governance structures amongst the Khoi and San communities. I just got back from the Northern Cape and sitting in a hearing where the parliamentary committee could not be bothered to have made arrangements to translate into Afrikaans, which is at the very least the common language spoken in the Northern Cape, if we set aside Khoi and San languages. And so this idea of, we're doing this for you to recognize you, but we couldn't really be bothered to do it in the language that speaks to you, is for me an illustration of what I think is a massive gap, actually, and perhaps a gap that we haven't gotten right in the same way that we might have during the negotiations process.
Thanks, Jimmy.
Thank you very much for giving me this very intimidating opportunity this afternoon. I think when I first read this quote, my initial reaction was, yes, that's absolutely right. And then on my second reading of it was, well, we have to first start off with asking, what is legality, what is law, before we can decide if we agree or disagree with this. And I think I agree with Joel in his, what I suppose could be labeled a conflict of laws situation. For example, in the context of colonialism, where you have an indigenous people who fundamentally disagree with the foundation of the laws that were implemented by the colonists. But I think I approach this less from a jurisprudential perspective, because I'm not a jurisprudence expert at all, and more from an impact perspective. Because to me, I think the question is, what comes first, the power or the law? And so I see, let's take colonialism, that it was power that came first, and it was that power that allowed the adoption of a legal system. And so, in my view, it doesn't really matter if we call that law because it's moral or just or just plain wrong, because it had a very real impact on the people who became subject to that law because of the power imbalance. So in my view, that makes it fundamentally a legal system, but that doesn't characterize it as good or bad or anything else. And so, if law is a social construct, which I think it is, then it is constructed by a claim to authority backed by power. And it's where that authority and power meet that one party gets to decide what the law is and another doesn't. And I think what's so interesting about this moment in South Africa is that I think we are seeing sorry about that. I think we are seeing a conflict about whether there is still that claim to authority on the part of the ruling government, or whether that claim to authority has been lost. And that is something that I think has come out very strongly in the university student protest context, because we've seen increased securitization, as Rashida was talking about. And to me, that is illustrative of, in fact, a loss of a claim to authority, and that is why there is increased power through force that is being implemented. And so I think that this moment in South Africa is very important and very interesting, and I look forward to more discussion on that.
Thanks, Shamina. Samina?
Yeah, grateful for the opportunity to share some thoughts with everybody. I think going last, I get the benefit of, having heard what my fellow panelists have to say. And I'll say this much: I agree with a lot of what's already been said, and certainly I think the questions and the questioning that Joel raises are very important, and I think Nolundi makes similar observations. But my reaction to this slide was to say absolutely yes, and to say that, and to think that it really forces us to think about the power of law. But my further thought was to say, but these are the very easy situations. These are the very, very easy instances. What about our current set of circumstances? Because in as much as these are the easy situations, and we can kind of chuck them out with the garbage bag of history, because they were just so egregiously immoral and evil and wrong, law continues to be a part of our lives. And I think in any human society that has ever existed. Law has always been there in one form or the other. I mean, the very idea of constituting a society requires us to contemplate what rules are we establishing for ourselves. So I mean, I guess therein lies the idea of sovereignty, and I think that this is what Joel alludes to with respect to these regimes, that they were imposed and they weren't exercises of sovereign power on the part of indigenous Africans, or in our context. So having thought that, and being somebody who's constantly thinking about imagining how we can constitute a different society, this slide then brought me to think about myself as a law teacher, myself as a lawyer, myself as somebody who holds a certain amount of power, which I then want to reflect back onto you as members of this session here. And I think an important question that we need to ask ourselves relative to this particular slide is, what is the power that we hold at this very moment? Because in as much as apartheid is now something which has been banished to history, we live with its material consequences now. And we need to think very much as legal scholars, legal researchers, law teachers, and so forth, what part we play in shaping those questions, or shaping how we understand what is the justice that this current moment demands of us. Because I think in many instances, we are also ourselves caught up in this realm of legality, and taking the law and interpreting the law, and not necessarily connecting this law to our own sense of justice, and I think in many instances probably not being adequately critical, or at least not being adequately critical of what we mean by justice. And I think fees must fall, for me, is kind of a classic example of how we ourselves at this point in time are caught up in a realm of legality that I think has become about holding the line, has become about desperately seeing how we can make the 1994 constitutional moment continue to resonate and be unquestionable, when I think the students and the many, and it's not even just about the students, and the many communities where there is protest on a daily basis in this country are asking deep and far-reaching questions about historical justice. And so this is without going on and on, these are some of the issues that this slide forced me to think about, really. And I want to repeat that question: is what is the power that we hold at this moment? Because we do hold power, and some of that power plays itself out, and this will be the last moment, in the silencing that I've seen happening in the context of fees must fall, with academics who hold particular views being labeled and being castigated as if we, I'll say we are supplying the petrol to burn the libraries and so forth and so forth. Yet it's really about our different conceptions of justice and what we believe this moment is forcing us to think about.
Thank you, Sibanda. For those colleagues who haven't been part of the sort of more intimate information on the protests, etc., I just wanted to share some statistics. 12 of 100 children make it to university in South Africa. 60% come from the wealthiest of the 30% of fee-paying high schools. These are private high schools and what we used to call the Model C high schools, which are also fee-paying high schools. So 60% of university students are coming from a very elite level. 50% of white school leavers go to university, as compared to 17% of African children. Now let's talk about justice. Let's talk about changing the landscape. Let's talk about our own culpability, looking at statistics such as this, and contextualizing the student protests in light of this. What are the demographics? Who teaches? What do we teach? How do we teach? What's our pedagogy? What syllabus do we put forward? And I think over the next 3 days, many of these discussions will happen. Joel, and then I can open up to the floor.
There's a concept called colonial unknowing, which is what happens when the dominant group in a society produces forms of knowledge and structures society in such a way as to erase the colonial foundations of that country. In South Africa, because white academics dominate the academy and so forth, there's been a concerted effort in many disciplines, including law, to erase the fact that South Africa is a settler colony. So we have in South Africa the very bizarre situation of over 90% of the population being under the social power and control of 8% of the population of a settler minority. Now, this is very important. It has to be reiterated because you could not understand much of what is happening in this country without understanding this fundamental problem of conquest. And so there's been a concerted effort to erase conquest. One of the ways conquest has been erased is, particularly in South African law, to speak of apartheid. So people say, we are a post-apartheid country. Now, those of us who know when apartheid begins will know that it's a 48-year episode in a much larger history. So to focus on that vulgar, legal-driven form of domination without thinking about how land dispossession inaugurates this place we call South Africa. So the very idea of South African law is designed by and for the conqueror. So what students have brought up is they're simply repeating an old problem. This is the nightmare that will continue to repeat itself, as we're in South African society if we don't deal with this problem now once and for all. I mean, I'm just thinking about also the way we think about the Constitution. And in its most basic sense, a constitution must constitute. In our case, we needed a constitution that would reconstitute power relations. It did not do that, this constitution, and it could not do that because it was based on a process that could not allow it. So you were talking about the constitution-making process, but we all know, if anybody reads as many books as has been written since '94, is that there were negotiations behind the negotiations, which set a limit on the kind of things that could be spoken about and on the kinds of things that could be engaged on. So, of course, people know what I'm about to say, the property clause. Property is not a normal, it's not an ordinary right like all the others. It's not like freedom of assembly or so forth. Property is a marker of social status. It determines the nature of the quality of a person's existence. So once you don't deal with the property question, and white people did not arrive in South Africa with land and cattle and livestock and property and workers. They arrived here alone and they dispossessed African people of what belonged to them. That's the founding, originary moment of violence that will continue in every sphere of our social existence if we don't address it. So, the thing I want to leave here is we can't talk about law in society without talking about conquest. And the thing that lawyers get involved in is to technicalize and depoliticize what is fundamentally the repetition of a historical problem that will keep coming back and back and back until you resolve it. So that's my push to, if we think about law in society, where does colonial racism fit into your analysis? Because we have an untenable situation in the country at the moment.
Thanks, Joel. So Joel is asking us to reflect and excavate deeper and deeper so we can understand structural, systemic, pervasive, widespread factors that underpin where we are situated currently in December 2016. I'm going to, unless any of the panelists have something burning to add, we're going to come back. So I'm going to stand. It's easier for me to see. I see Ben.
This provocative quote asks us to think about power. So I have a question for all of the panelists about slavery. Slavery is actually indigenous to Africa. As is, of course, gender inequality. And in fact, power is ubiquitous in human history. It doesn't just start with colonialism and apartheid and so on. And of course, inequality and exploitation are ubiquitous as well. So this is not necessarily a get-out clause for racism, sexism, colonialism, apartheid, and capitalism, for that matter. But it does suggest that it's more complicated than simply talking about the moment of dispossession and looking back in time and trying to reconstruct a version of the past. It may be that actually what we're talking about is something new that we have to create.
I wanted to pick up on this sort of framing notion of legality as an instrument of power, and then obviously by extension, and all of you have spoken about it, law is an exercise of power that governs the social, right? And the body is in that social. And I wonder how we reconcile that idea, that figuration of law, legality as power, with the notion or possibly even desire for a pure or true law, which I think in some of the conversation has been invoked. And I wonder if this desire for a pure or true notion of law, which I don't believe exists, if we see law as exercise of power, doesn't, in a sense, erase precisely the way in which law itself is constitutive of relations of power. So how do we historicize current injustices without, in a sense, invoking a fictitious desire for a purity of law, and by extension, a set of social relations that are by definition naturalized. And for me, one of the things in trying to think about that I've been grappling with is how we think about law radically as a site of productive political contest. And if we do that, how do we make sure that we center ethics and we center issues of justice within the idea of not a fixed point? Law is never a fixed point. So I was curious to hear what people may think of that.
Given what the panelists have said, would you, as an all things considered, what is good for South Africa and South African people, support a constitutional assembly to redraft a new constitution, or would you not?
So maybe as a very brief response to Ben's question about power and its complications, I mean, I think I definitely agree with that we have to see all these issues as being intersectional, and we can't deal with them in pockets. So we can't deal with race as an issue in and of itself without dealing with race as it intersects with other issues like class and gender. And so, I mean, I think I agree with you that this is about a broader question. This is something that was very interesting for me in Rhodes Must Fall at UCT, and the emergence of patriarchy must fall within that movement, and how there was a challenge between women students in the movement against male students in the movement, and the emergence of the trans collective in saying this is not just about race, this is not just about blackness and whiteness, this is about how women are treated, this is about the invisibility of homosexual people and trans people and disabled people, and we need to see this all as part of the same issue with its own diverse and unique issues. And so I think that while I agree with Joel, we have to start in South Africa with the moment of conquest if we are ever going to go forward from that point, because that remains a scar that has been left untreated for far too long. That doesn't mean we haven't, that we don't have other issues as well that must happen alongside and also specifically.
Well, mine is just a brief response. I mean, we know now through the tireless archaeology and working of many people that African history does not begin with the arrival of Europeans. So I do find it strange often that people say, whenever one talks about African history, that you're invoking a fiction, as though Africans grew from the soil after Europe, or that there's some period at which nothing existed before. So there was an African law, a notion of law, and a mode of social organization that had particular characteristics. This is not a fiction, but black people, are, like everybody else, has been existing and breathing for a very long time, long before the Europeans arrived. So I'm not invoking any fiction of a pure law. I'm saying there were competing norms about how you organize a society. And the kind of legal order and jurisprudence that arrives through conquest was fundamentally different to the ontology and epistemology of the people it found here. This is not a fiction. It exists as African people have been existing. And to Ben's question, of course, I mean, I think it's far more complex than that, but I think the question we need to ask is, what is the nature of the how do we interpret the antagonism in South Africa presently? And although there are these subtending and competing history, it does appear to me that the fundamental antagonism today turns on the problematic of conquest and along the line of race. And of course intersecting with or producing along that line class, race, sexuality, religion, and other lines of contestation. So my position would still remain that although the history is certainly much more complex, but I'm saying right now in South Africa, if we are to understand the continuing racial slurs, the most recent one being from one of Cape Town's very own, I think Vicky Hartley, black people are like animals, they must go away. They were also in Durban and everywhere. If we are to understand fees must fall, if we are to understand, for example, a recent decision in the Constitutional Court around the naming of streets and symbols in Pretoria, where the judges quite significantly were divided along the line of race. The last two remaining white judges, as it were, against the black judges, on a very sensitive issue concerning colonial history. So I'm saying, though, to understand that, you've got to go back to 1652, and you can't sort of muddle it up, one, by saying South African history is a kind of fiction or African culture. Any invocation of African culture is always romanticism. I'm not romanticizing anything. I'm not saying things were perfect. I'm saying things were certainly better, or things were different, no doubt, prior to conquest. And it's not enough to say, well, there were other iterations of the same problem, both on the continent and elsewhere. We must deal with what I think presently organizes our social reality. I just want to say one more thing. You also cannot understand, for example, what is emerging politically in South Africa around corruption and state capture without understanding colonialism and without understanding racial capitalism. Because again, and lawyers have been very much a part of this, is how do we define social problems? People are saying our biggest problem is one man, a president, okay, who has almost no power since the collapse of the nation state, if one is really serious, and one family that I think has less than 500 million or whatever. I mean, we really need to think very carefully. What is being erased, in other words, when we think that the major problem in our country today is a 74-year-old man and a small family that lives in Joburg?
And it is Anti-Corruption Day today, International Anti-Corruption Day.
And picking it up from where Joe left off, I will maybe add a little bit in response to Ben's comment and question. Absolutely, slavery, I won't say it's necessarily rooted in Africa, but there's a history of slavery, a history of inequality, of exploitation that was probably indigenous. But the point is this, though, that particular history gets subsumed by another history. And in being subsumed by that other history, we need to connect the contemporary to the history that Joel is talking about. That takes us back to 1652, and identify those continuities that continue to frame and structure our society, which places whites in a particular position with respect to economic, social, cultural capital, and blacks in another position. So I don't think it really takes us much further to make those points. And I don't think that you are necessarily doing this, but I think in many instances when people do raise that, it's a duck. You're trying to, it's an attempt to duck the issues. And on the other, I think it's a form of silencing that says, well, if you can't account for what happened historically, well then, kind of let's move on. And I don't think that's what you're doing. I hope you're just being provocative and trying to make us deal with this. And then to link with the question by I think Melanie from the back, to link that a little bit with this idea then of silencing, and at least what I'm saying ends up being silencing, and the questions about a pure idea of law and ethics and justice and so forth, is to say that I think ideology matters. What intellectual ideology and the intellectual tradition that you draw from really counts, because this is where I think to kind of talk about ethics and justice without putting forward what your ideological or philosophical perspective you are coming from ends up in a situation where we talk at cross purposes, and we fail to really interrogate, I think, the most powerful hold that European or Eurocentrism or European modernity continues to, the type of power that it continues to exercise over us. Because this conversation, even amongst ourselves as blacks, is impossible to have. It's not, probably is impossible to have in an indigenous language, because our languages became stunted, and in the minds of many of us, they couldn't be developed, or they're just these languages that must remain at the periphery. And a lot of that has to do with the history of ideas and the history of how culturally our society gets established, where anything that is European or emanates from Europe is necessarily superior, and anything that is African is necessarily inferior. So if we're going to talk about these things, if we're going to talk about I guess ethics and justice, I think we also need to be quite clear that philosophically or ideologically, where are we coming from? Because for myself, I tend to think from a liberation point of view. It's a particular type of liberation discourse, or a particular type of liberation philosophy that was aware of the possibility of new forms of oppression coming into being. But it's a consistent commitment to the idea of liberation and identifying everybody who is oppressed and seeking to undo that. So those would be my comments to that comment. James, yeah, that is the million-dollar question. Would I advocate for a new constitutional assembly at this point? I would say no. I wouldn't advocate for a new constitutional assembly, because I think at this point in time we haven't actually managed to, for ourselves, identify exactly what the nature of the problems are and where do we go from here, which is why I think in many African countries constitutional moments come and go, and what you have is a rearranging of the seats, and I think certainly ideologically we seem caught up in a space where we believe constitutional ideas start and end with liberal democracy, and this simply isn't true. Just not enough thought has gone into doing things a little bit differently, and that also has a lot to do with the history of how constitution making happens, and the powers that are at play at those moments where constitution making occurs.
To Mel's question around how do you get around the sort of harking back to an idea of pure law, and my response would be, I think that it's to liberate ourselves from this idea that there is such a thing as pure law. I don't fully believe that there is such a concept as pure law. So if I think about it in the context of living customary law, right, and this idea that there are rules, and so one always finds the rule in law and applies the rule, but there are multiple examples in the context of customary legal systems where there is a rule and everybody does something completely different, and so the rule is used to sort of explain the practices and the norms and the conduct. So I think that it would be a very powerful thing to release ourselves from this idea that there is such a thing as pure law. And James, I would agree with Sanele. I don't think that we're at a point where we consider redrafting the Constitution. And for me, I think it's because I haven't yet been convinced that we've gotten to a point where we need to abandon ship. I think that there is scope in the Constitution for creativity, which will be challenging, but I do think that there is some scope within what we have to make it work better for us. So if I think, for example, around the issue that we're often asked around 25.1 and the fact that, until you sort of get rid of Section 25.1, which protects private ownership, you're never really going to be able to have a proper sort of restitution of land and land reform in the country. And so you have, very radical positions that are advocated by political parties like, for example, the EFF, around going back and taking back land, even though, Section 25.1 protects private ownership. And for me, I hear that, but I feel like it's a slightly incomplete conversation, because the current sort of systems of protecting property rights in South Africa and land-holding mechanisms are such that they would still exclude people. So fine, you take the land back, but if you're taking it back into the current system that's built around the cadastral system, a very detailed system, you're still going to end up with people who are outside of the protection that is ostensibly offered by private ownership as we currently understand it. So it's a two-part conversation, and I feel like we haven't had the second part of that conversation. So I guess I'm just trying to make the point that I think there is still scope within what we have in terms of the Constitution to challenge ourselves a lot more to make it work better.
I just want to pick up what Melundi was saying about, in response to Melanie's question about pure law being a fiction, and to just absolutely agree with that. Law is made by people, and people are never going to be perfect. And I think it's when we fall into the trap of thinking that when we have a law, it is the answer to every problem that we might have. That's when we get into the real difficulty of not wanting to move outside of that bubble. We have to see the law as a process towards something that we may never achieve or attain, but that we have to constantly try and get to. So, for me, the process of law, the making of it, the implementation of it, the breaking of it, that is the real important part of a legal system. It's challenging ourselves to think about where the gaps are, what needs to be done, and that changes over time because new issues crop up, we realize new things, we have different needs, and so we can't think that because we have a good law today that, great, fine, let's move on now. That's just not how law works. And I think that at the moment, maybe this is naive, I'm not sure, but we have the law being such an important part of public discourse at the moment. Everything from Oscar Pistorius to Praveen Gordon to e-tolls to the public protector. I don't think the public has ever been more aware of legal processes and laws as we are today, helped along, of course, by media and social media in particular. But to me, even though most of those things are problems in our legal system, I see that as an affirmation of our legal system rather than its breakdown, because it says to me that we are in the second stage of development of our legal system. It's not perfect. By no means am I saying it's good or perfect, but that it needs to be developed and we need to be grappling with it. And to me, democracy is at its strongest when people rise to defend against that which they disagree. And that's what I see happening at the moment. And that is part of the project of not talking about a pure law, but getting to a point where we have an equal society. Thanks.
We know that it was the processes of law that really kept colonialism and apartheid in place. You couldn't have kept majority of the population, sheer force, but mostly law. And we see, for example, the way that the anti-apartheid movement used law very, very strategically. And then you look at the great struggles, quote-unquote great struggles, starting with Nelson Mandela's sort of speech in the dock, this sort of challenging the conceit of colonial and apartheid laws to actually live up to what they said. So you see this. You see the trade unions using law very strategically during the apartheid era and so on. So I guess my question is, when I look at the sort of fallist ideology, I'm just using it very broadly, there's a rejection, in fact, of the constitutional negotiations and the Constitution itself. So I'm sort of interested in exploring what what role for law, because law was so important both for those who wanted to enforce apartheid as well as those who fought against apartheid. And the reality is that the revolution in South Africa was a legal one. And so where does that leave us with this particular moment, at this particular moment? Thank you.
Okay, so before I answer Penny's question, I don't think a revolution can ever be legal, because revolution is about the suspension of law in favor of a new law and a new law of the earth. But I just want to push my panelists a bit. I think, Melanie's question is very important, because that's how many people respond to any call for colonization, that you are romanticizing a pre-colonial past and so forth. This is very problematic philosophically. You will know, for example, that people like Hegel and many European philosophers theorized Africa as a place in darkness. So the idea that to retrieve African history is to retrieve myths and falsities, is to say, in fact, we were in darkness, and we are foolish, those of us today, to return to fetch the darkness, because we had nothing. I mean, if you go to history departments across the world that teach Greek history, ancient Roman history, that teach Roman literature, nobody ever accuses them of romanticizing anything, despite how ancient, how old, and how highly contested the historical record there is. So this is very serious. The idea that it's only Africa that was in darkness, and to even speak African history is to already participate in kind of witchcraft, as Achille Mbembe puts it, is a very serious charge. You don't need to concede that you don't believe in a pure law. I believe that Africans existed before Europeans arrived. I believe we had a way of knowing and thinking and being that is worth trying to reconstruct. There's nothing pure in the world, because all things are constructed, all things get mixed up in history. But to use that language, and I understand it's a very popular language around anti-essentialism and so forth, and people like Achille Mbembe made that very popular, to accuse people. I mean, we have someone like Chik Anta Diop, Theophile Obenga, who've done that work. Now, his history is highly contested. I'm not saying it's perfect and we should take it as the biblical word, but Africans were not in darkness. We found ways of reconstructing our history, and it is worth engaging. And this is important when we talk about decolonization, because that's the first thing I hear from people say, well, Joe, we don't know what decolonization is because Africa kind of didn't exist until we arrived. Nonsense. And that has to be challenged quite fundamentally. But before Penny's question, I don't think that it's only the fallers who are against the South African Constitution. I think a long view of history will suggest that if you look at black political struggle in South Africa, and you look at the Freedom Charter, 1955, and the debates around non-racialism, I think that's where the major debate began, which is, do we fight for democratic inclusion into white South Africa, or do we dissolve white South Africa and create what the Azanians called Azania? This is a very serious debate that, of course, as you know, split the liberation movement. The group that won were the Democrats. They wanted simply to be treated like the white man in South Africa. The history of the ANC was to go to Britain and to beg the Queen for clemency and so forth. So what I'm saying is that the tradition of decolonization represented by the BAC and Black Consciousness Movement was overtaken and erased by the ANC's tradition, which was about democratic inclusion. So the ANC did not sell out because they never wanted self-determination and African liberation. What they wanted was democratic inclusion into settler-created South Africa. And that's what we got. So nothing can fix the problem until we address it. I mean, that's what I'm saying. You can't tinker with the Constitution until you really figure out what is our present situation. So a few things. You have, for example, a constitution which, amongst other things, mandates constitutional supremacy and a very powerful system of judicial review. It has many important elements for liberal democracy. But what's most important that it does is that it encumbers the radical potential of a black majority government, right? It limits what a black majority, it limits the possibility of a revolution through law. Then, of course, we have the property clause. I don't think we need to talk about that. Property was taken on the basis that the people who were on the continent were not human. If you allow that property right to be recognized, you accept that racist doctrine in toto. And so even though, and you're quite right, we won't simply fix it by reversing the colonial, by reversing the land problem, because there's also a very gender dimension to land ownership in certain parts. But the property clause also represents a moral vision and a moral view about what happened in South African history. And if you don't address that kind of problem, then you are still stuck in a very serious contention. Land is not just about eating and walking. It's a symbol of something deeper. And
And that's what I think we've lost. So the students who are the fallists are very correct to raise the problem that the Constitution reconstituted society in the wrong way, in a way that continued relations of conquest rather than ended them.
Rashida, can I just reply? Sorry, to Joel. So, I mean, this idea of pure law, I'm certainly not saying that Africa was, had nothing before Europeans came and settled here. For me, the idea of saying that there is no such thing as pure law is that what I'm actually saying is Africa has absolutely got its own way of doing things, and that is a system of life, it's a way of being, it's a way of knowing, it's a way of interacting with each other in the world that is as good, as important, as valuable as all other systems of knowing. And so I think in acknowledging that there's no such thing as pure law, I'm certainly not saying, okay, well, because there's no such thing as pure law, that period before, the European settlers arrived is sort of a black hole. But what I am saying is that I would really, really put releasing the idea of pure law as a challenge to what has been held up as the absolute pinnacle of law, which is a positivist, black letter, rules-first idea of law. And it's those sort of, forgive my wording, but it's those people who worship at that altar who I am saying need to release the idea that there is this thing that is called a pure conception of law, and acknowledge and understand that there are other fundamentally important and perhaps even better than ways of knowing and being and engaging with the world that are completely different to the black letter law, but that in and of itself is not the absolute be-all and end-all.
And I actually liked very much Ben's comment from earlier, and it's resounded very well with some of the arguments that were made in the panel that it's not 1952, that's the starting point, right? That you have to start from earlier. But in a way, you must start from way back if you want to give ourselves the ability to reconstruct what was before. Instead of just saying, well, it's us against them, it's the mythified kind of African will against colonialism. What I mean to say is that if you want to allow for this reconstruction, you have to allow for the fact that law is not the only thing that's messy, power is messy too. And what I mean is that, of course, it's not about comparative pain, it's not about silencing and saying and denying that there was real violence and that this violence was unilateral. But it's also about re-embedding this particular moment of violence in something that's actually a bit more complex. What I mean is globalization as the encounter between something that's imported and something that is imported by and on did not start with colonialism, right? And if you recognize that, and you understand, for instance, slavery is one typical and core example. Slavery is part of the fabric of many African societies. It's internal to the fabric of African societies, which also means that Africa, way before this typical, very, very small moment of European colonialism, was at the crossroad of multiple trade routes between Asia, between other parts of the world, which also means that when colonialism happened at that particular phase, it got embedded into power structures that were there, that got transformed, and that got reconstructed. So what I mean then is that when you say we can't have a revolution through law, but actually law is all about revolutions. Why? Because law is the only thing or one medium that has this uncanny ability to transform what is old into what something looks like, into something that looks like new, transforming old bottles into new one, transforming the layers of the past into something that resembles the future. So if you want to allow for this reconstruction, you need to re-embed this long process, this long duration, and reposition these moments of reconstitutionalization, such as 1994, within this long durée. Of course, I just started in the UK, and the UK they're all about impact of research. And impact of research at some point becomes this very insanely dangerous process where, like, there's this joke circulating, like, you know what kind of research has been, like, socio-legal research or scientific research that had the most impact in history? Gas chambers, right? So, like, we need to stand back and think, at least in Europe, that's like, it's a core idea, that we need to understand precisely not only the socio-legal system within which we stand, but also what kind of research and for whom we are producing.
Earlier this year, I was teaching a constitutional law class, and like many academics in South Africa, I described the constitution as the final constitution. And the student raised a question and said, but Prof, I think you must not define the constitution as the final constitution, because the people are going to decide what is the final constitution. This is not the final document. And so the question I want to press on Plenary is to say that in one of your pieces, you also describe the 1990s negotiations as resulting into a miracle that came out of it. But I think you and I and many academics know that the Constitution was a result of negotiations that had predetermined parameters within which to negotiate, which means that they were not free negotiations, to put it that way, that you had to negotiate within certain parameters to produce a document that we call the Constitution. So I want to engage you, Sanele, to imagine a constitution for South Africa without the predetermined parameters that were set in the 1990s. And to then ask whether you think the problems we have, and you have all, I think, well articulated them, can be solved within the current document or within the law as we see it today, or elsewhere, whether we can solve these problems outside the Constitution as we see it today, or we need another document that can be able to help us address these problems. One of the panelists there talks about law and power, and which one comes first. I think the question is also directed to you. Thank you.
It's true, I don't hear people saying you are romanticizing intellectual property law. That word romanticizing is usually used in terms of African history, purely. And also to note that the idea of pure law, I don't take it as a compliment. I think it's, in jurisprudence, is the idea of the primitive law. That law evolves and it starts as primitive and pure and tribal law, then it becomes complicated into the modern society. But my question to the panel is, I'm looking at South Africa and the struggle for equality among race, and I'm seeing a lot of struggles. I'm seeing the struggle for women, I'm seeing the struggle for sexual minority, I'm seeing, and I'm wondering, my question is this: is it possible that the struggles have become too big or too many, that it has kind of clouded the issue of racism? Can you prioritize, or because every struggle is pushed into one and bundled into one, and so South Africa is going with a lot of struggle where somebody just wake up and say, to me, this should be the struggle, this should be the priority, and there is wisdom in pushing all the struggle to equality of all human beings, but is there a way that it probably clouds or denigrate the actual struggle of race when we are chasing every struggle and every equality issue and forget maybe the priority? Is that a possibility?
Thank you.
It seems quite apparent that the issue is with regards to power and the role of power in human interactions. And I guess in the case of South Africa, because power hasn't quite shifted, there isn't that clear shift from white power to black power. It still seems that that is the issue. But coming from a West African country where white power isn't in consideration, I can say that the issue of power is about, at the end of the day, boils down to economic interests and who controls those economic interests. And so, at the end of the day, there will always be vested interests to protect. In the case of South Africa, it just happens to be quote-unquote white power. So if we were to go all the way to the extreme, what would you say is the end goal? Even if you were to, what would you propose a distributive justice framework to balance that power so that economic interest is spread more evenly and there's no concentration? Because even if you end up with a Mugabe-like situation where you chase all the white people and you have only the black people, there will still be power and economic interest concentrated in the hands of the few. And I think for me, that is the real issue. We shouldn't, race is about propagating a narrative that ensures that your economic interest is protected at the end of the day. So every other thing is a coloration of that protection of economic interest. In the case of South Africa, it's about white ownership of land. In other places, about natural resources, and that's why you end up with civil wars that last years after independence. So how then do you balance that and ensure that whether or not you have a white population, because South Africa is in a unique situation where you can't just ask all the white people to go. You guys have to live with each other. How then do you live with each other in such a way where you can balance power and economic interest is spread more evenly?
It's a form of a misnomer to say, yeah, Africa had slavery and patriarchy. So what? So does it legitimize European colonialism? Because yes, you also practice it, so now that we are doing it, it's like saying what the ANC is doing. Yeah, white people stole and no one said, now that we are stealing, it's a problem. Does it make it right? It's still theft. So I think there's a certain illogical way in which we want to argue to naturalize dispossession, to naturalize all the inequalities that has been perpetrated in South Africa. And it brings me to the central question. I think someone raised the question about the Constituent Assembly. The question is, which class interests were pursued in '94? And do you think if black people, proper, the working class, and those who were landless were central in the voices in the constitutional making process, would we have a different constitution? Would they have accepted a property clause that perpetuates landlessness? And this is the fundamental question, because I think the constitution were drafted by elites in this room who allied themselves to a previous power structure. And so there's a lot of continuity. The second question is, if you argue, which you say, no, in the one hand you say the law is colonial, it is embedded within colonial law, and on the other hand you say, no, we haven't pushed the constitution, we haven't worked it, made it work much better. So I find it a bit counterintuitive, your argument. So the second question is, how much of the remnants of Roman Dutch law and all of this colonial law that you so elegantly use to argue your point are still embedded in the legal framework? And then the third question that I wanted to pursue is capitalism. Can we, the question is, the law is in the interest of who? It is never in the interest of the poor. You might have a Grootboom judgment, you have my TAC, but in the end, it is there to serve the interest of the capitalist class and those ones in power. And I want to see how you reconcile the economic structure with law. And with the two, would you just impose an alternative society using the same legal framework? Thank you.
Sure, a lot to chew on. I'm just going to jump on only a few. South African legal discourse in particular, but I think across the board, it's quite interesting for the reason that this is the one country that I know where academics openly worship the South African Constitution and almost regard it as untouchable, and you know, anything you say about the Constitution is unspeakable. I've seen a lot of people, judges and academics, literally horrified by the idea that there's something wrong with the South African Constitution. That's the pure law problem we have in this country. The idea of some pure, perfect, worshipped constitution. I mean, the nature of prohibition about even saying anything, I mean, these are facts of history. The Constitution is an outcome of compromise. Anything that's an outcome of compromise means that the historical justice claims of the people were sacrificed for something larger. As people put it, it was a reconciliation without justice. So I encourage very openly legal scholars in some way to become more political, for us to do better history and to see that this constitution is neither perfect, and in fact, maybe it's time to really think about it. Maybe dusk on its epoch has arrived. I would say it was always, the constitution was always a problem, because the Freedom Charter was always a problem, because the ANC's vision of liberation and non-racialism was always a problem, and because conquest was always a problem. So that's the first thing we need to get over in South African legal scholarship. It is almost unspeakable. And that affects a lot of things, Certain people, I wouldn't get funding if I wrote a research project like, I want to write a full paper on a critique of the Constitution to show that it's a complete fabrication of white liberal interest. I mean, I wouldn't get any funding in any academic place I know that is sensible. Because there's a certain kind of scholarship being encouraged in this country for us so I'll just leave it there. But except to say that there are communities like, for example, the organization known as Kulumani, which is Speak Up of Victims of Apartheid, fighting against a negotiated settlement, its outcomes, the economic conditions that it's created, the landlessness that is kept in place. So, the contestations, I think, are still there in communities. I just want to say one last thing, which is it might conflict with what I think is popular, which is about what the brother they raised. Analytically, I would say you are right. Race, or at least racialization, which includes capital and gender, is the primary antagonism in South Africa right now. And there's emergence of a discourse of intersectionality has been problematic because it's one thing to say powers of oppression intersect, but South Africans are saying they are symmetrical. And they are not. As if capitalism and white supremacy and patriarchy had a meeting and were like, we'll take 25% each of the That's not how social powers work. Sometimes it's not that gender and race intersect, it's that race produces the meanings of gender that are different, or race produces relations of class, right? Or that race frustrates notions of gender that you'd find in white societies than what you'd find in black communities. So I do think that the notion of intersectionality and the idea that race is just one amongst many problems is a problem, analytically and politically, because it confuses what we are dealing with in this country very seriously. So, I mean, I'm not making a case against intersectionality. It's a very important way of bringing to the fore what is forgotten by singular analysis. But I think we mustn't confuse intersectionality with the idea that oppressions are symmetrical. I mean, for a long time, whether you're talking about Marx, for whom class was central, and Marxists, for whom class was central, feminists, from whom the operation of gender was central, now we just say all these things are equal. And that's highly paralyzing, because they're not. We need to understand history. So my call would be we need to return to the history of how power has been constituted, and not simply be politically correct in order to comfort white fragility or to comfort a particular story of the transition.
I actually just wanted to respond to Penny's question about fallists and whether fallists, believe that the whole legal system must fall. And I think that that's something that I'm not sure is really true, even while some people in Fees Must Fall, Roads Must Fall might say it.
The Constitution, not the whole legal system.
Just the Constitution, okay. Because something that's very interesting for me is, if we consider the Constitution to be the cornerstone of our legal system and of our democracy, then what does it mean to say that the Constitution must fall? And what does that say about the rest of our legal system if everything else needs to be not in conflict with the Constitution? Because I think, even under apartheid, as Joel was saying, that there were parts of the anti-apartheid movement that very strongly felt we must completely disassociate from the legal system and the social system at that time. And yet what I find to be an interesting question, I'm not saying this is an answer, but people still continued to get married in court, people still continued to register births, to get driver's licenses. And so, what does that mean in terms of, is that about pragmatism? Is that just saying, well, this is what we're bound by, and so in order to live in this space, those are the things we need to do until such time as they change? Or was that in some way a fidelity to the law in its, big construct, not necessarily in its individual pieces that were contestable? And I think that's an interesting question that I see in the student movement today, because even while, and there are some parts of the, I've heard some people within Fees Must Fall and Roads Must Fall say that not just the Constitution, but the whole legal system needs to change, and yet, simultaneously to that, a colleague and I were having, I think, a bit of a chuckle about how photographs taken by Fees Must Fall persons have now been copyrighted, which is just, you know, very simultaneously to saying things like knowledge ownership and property ownership is something that is colonial in nature. These photographs have been copyrighted. And I think that's just very interesting, and I don't have an answer to it, but it's a question about, does that mean that in this country we have a fidelity to the law even while we constantly disagree with individual components of it? And then, sorry, just in relation to Sarah's point, I mean, I think that as a teacher of law and a researcher, I do think that we need to find a way to decolonize the law and the teaching of the law, because you know, I feel like I can't keep talking about white colleagues who are perpetuating a particular type of legal scholarship, or anyone else for that matter perpetuating that type of legal scholarship. I am now a scholar that has been taught in that system and is perhaps perpetuating that type of legal scholarship to my students. And so, you know, what is my responsibility to decolonize and to reimagine my understanding of the law so that I can teach it differently to my students? So, yeah, not an answer.
Right, thank you. I guess it's Penny. Yeah, it was a response to Penny, but it was to say that I find it difficult to pin the four lists into one particular ideological position, because it's a very, very diverse movement where there's shifts and turns, and a lot of it depends on which campus you find yourself and who are the most prominent voices. So, I mean, Penny qualified her question to, I think no, maybe not qualified, reiterated her question to say it's focused on the Constitution. At WITS, one of the calls is to engage in a constitutional case around Section 29 of the Constitution, which is the right to education. So, to characterize the Fallist movement as an outright rejection of the Constitution, I think is not reading the movement in its full diversity. I think I'll say that much. And then just a few brief comments to Sarah. I don't see the need to always to go back and look at history and the messiness of history. It's important to know it, but what should inform us is what question and what circumstances are we trying to deal with. Because there's really no point in a South African context than to want to problematize slavery, which does not, a slavery that doesn't inform our current circumstances. Because it might be historically interesting, it might be academically interesting, but then if we're connected to Fees Must Fall and the communities in South Africa who find themselves marginalized, excluded, and really don't feel that 1994 delivered, that history just doesn't inform their reality. So cool. And then, but I think you also in your second question might have also answered yourself, where you said we need to think about the type of research that we do and who it's for. And I think you brought in, globalization, and if we think about the neoliberal university, the research is for most of us research for our employers and for our careers. It's not necessarily addressing the most pressing social questions that drives our research agendas. And that's why when I was responding to the slide, I wanted us to think about what power it is that we exercise, and to think about our own individual agency, because there are lots of us for whom it's just a great opportunity to go on what a former head of school of ours called academic safaris, to go to different places, meet other people, and write work that we hope that 10 people will read. So I think we also need to be honest about that. Some of us know there's a lot of us who do research that is just unconnected to the realities of the circumstances in which we live, in which members of our own societies, wherever we come from, exist. And we need to ask ourselves who that work is for. And if it's for yourself, that's okay too. But we need to be honest about it. Okay, so then I guess to Mtende, just a quick qualification. If in my work I've used the word miracle around the Constitution, I think I'm highlighting a characterization of how our constitutional moment in 1993 and between 1993 and 1994 came about. That there were people who simply, would never have imagined 10 years previously that it was possible, and my paper tomorrow speaks a little bit to this. You're right, the negotiations weren't free, but I don't think they ever are free. And Heinz is in the room, whose great book deals with this question around what influenced our constitutions. And then, the other question I think is just simply too big. Imagining a constitution without predetermined parameters, can we resolve the current sort of situation within the present constitution? I'm convinced that constitutional moments are not simply manufactured. They arise out of an idea. I think it's an Argentinian scholar, Gargarella, who talks about constitutional dramas. That there is a certain set of situations. There'll be some crisis. There'll be a certain set of events that brings about a constitutional moment where societies are left with no choice but to think about reconstituting and renegotiating. And because there's always particular sets of interests at play, there's always going to be some ground rules. There's no blank slate. I don't believe there's ever a blank slate when you go into constitution making. But what I will say, and it's partly a response to what Joel also raised, is that I think one of the biggest challenges or the biggest problems post-colonial societies have faced is that I don't think there is a tradition of constitutional scholarship that tries to do things differently or takes seriously the idea that things can be done differently. There is this idea. I mean, it's Francis Fukuyama's The End of History is widely disregarded these days. But I think in terms of how our constitutional societies are constituted, we are stuck in a liberal democratic framework which works for some, doesn't work for others, but very few of us are willing to push or ask those deep searching questions as to what can we imagine that is different. And it also can't be something that's just only imagined from the top. I think some of the work that Nolundi does in their unit is really, really important, because those are the voices that also have to come to play, because they have been left out of the constitutional setwork arrangements that we have in place. Okay, and I'll leave it there.
Sorry, Rashida, can I quickly respond to the gentleman in the back? Sorry. I can see him, I can see his blue shirt, I didn't catch your name. But you raised this idea of there being a tension and trying to use the Constitution and the current sort of legal framework to be more creative and to make things work better when it in and of itself is part of the problem. And I agree with you. I think that you highlight a tension that I struggle with myself. But my assertion that, I don't think we've stretched the Constitution enough and that we've used it enough to try and fix things is informed from a particular lens. So the Constitution sets up a pluralistic legal system for South Africa, right? So we're a dual legal system. Both the common law and the customary law are afforded equal status. But if I think about that conception, we have not gotten to a point where we are actually affording both of those systems equal status in our law. And I personally believe that the Constitution actually sets us up challenges us to develop a system of law that is essentially an amalgam of both of those laws, that becomes a system of South African law. And so until we've gotten there, until we've gotten to a point where I think we have managed to actually create a form of law and a body of law that equally respects both of these systems, I don't think that you can sort of abandon ship. My challenge, my personal challenge is, okay, fine, so you get there, right? You have this amalgamated legal system, you have this South African law. And what then if that is not the solution? And I think it was Jamila who made the point that law will never really be the ultimate solution. And I think that for me is a personal challenge because it pushes me, or at least it highlights my own lack of creative thinking. But it also really, for me, sharpens the point that both Sanele and Jamila made just a moment ago about asking yourself what it is, what power you hold. And it is uncomfortable for me to think about a sort of a point where that hasn't worked, right? So I like living where I live. I like living in an area where the buses run and things are on time. And to think outside of that box is a challenge, I think, for myself personally, but I would say that it's a challenge for all South Africans. And so perhaps a part of what informs what Joel rightly refers to as this sort of, don't ever speak badly about the Constitution, is because it is slightly scary to think outside of what has been presented as this saving grace, this document that freed us, this thing that we hold up and reify. So I just wanted to acknowledge that you point to a tension that I think is absolutely real, and just sort of explain how I get there.